My name is Antonio Ugas. I'm the director of the Center for the Study of Democracy and associate professor of political science at St. Mary's College of Maryland, the National Public Honors College. I'm pleased to welcome you to Historically Speaking, a series of lectures by scholars and researchers that shed new light on the political, social, cultural, and economic development of colonial Maryland. This event is sponsored by the Department of Anthropology and the Department of History at St. Mary's College of Maryland. It's also sponsored by the Center for the Study of Democracy, which is a joint partnership of Historic St. Mary's City and St. Mary's College of Maryland. With us today, we have Peter Laporte, the director of the St. Mary's County Historical Society, which is also one of our co-sponsors for this event. Peter will introduce our speaker for tonight, and with that, I introduce Mr. Laporte.
Thank you, Tony. And as Tony said, I'm the executive director of the St. Mary's County Historical Society. And we're delighted to have this opportunity to collaborate with the St. Mary's College of Maryland, and especially with the Center for the Study of Democracy and its director, Professor Uguez. And Tony, on behalf of our board, our staff, volunteers, and our members, I want to offer my personal thanks to you and your colleagues for your interest and support of Historically Speaking. We look forward to a long and continuing and rewarding relationship with you. Thank you. Before turning to this evening's speaker and program, I want to acknowledge a special guest that we have with us here at Anne Arundel Hall, the Honorable James Kenney. Judge Kenney served on the Maryland Court of Special Appeals from 1997 to 2007. He's also adjunct professor of political science here at the college and past president of the St. Mary's College of Maryland Foundation. And welcome to you, Judge Kenney. I'd also like to acknowledge Jonah Friedman, the son of our speaker, who made this journey with his dad here today, not so much for moral support and the drive down, but to take a closer look at St. Mary's College, and particularly the lacrosse team. And as we are speaking, Jonah is virtually meeting with some of his prospective teammates. And Judge Friedman, we're confident that you will encourage Jonah to make St. Mary's College his alma mater, and I'm sure that Judge Kenney concurs with that recommendation. The Honorable Judge Daniel A. Friedman is this evening's speaker. He sits on the Maryland Court of Special Appeals, to which he was appointed in 2014 and re-elected in 2016. Now, I have to confess, I had no idea at all what the Court of Special Appeals is or indeed does, so I had to look it up. It was established in 1966 as an intermediate appellate court to handle the increasing numbers of appeals to Maryland's highest court, the Court of Appeals, the Supreme Court of Maryland. The Special Appeals Court exists for appeals out of right, meaning that it will hear all appellate petitions, not just those which the judges deem to have merit, as is the case with the Supreme Court or the Maryland Court of Appeals. Excuse me, it's a court in the middle, if you would, so to speak. Judge Friedman earned his law degree from the University of Maryland, and among other wonderful things has been Associate City Solicitor and Chief Litigator for the City of Baltimore's Department of Law from 2000 to 2002. He served as Deputy State Attorney General and Counsel to the Maryland General Assembly, and prior to moving to the Court of Special Appeals, he was an adjunct professor at the University of Baltimore School of Law. Judge Friedman is known as a rigorous jurist who strives for a thorough understanding of both sides of the cases that are brought before him. And as part of the process, it is rumored that Judge Friedman encourages his clerks to keep a pair of running shoes at their desks, as he sometimes likes to discuss his cases with them during long walks around the third floor of the courthouse. Tonight, Judge Friedman will speak on who came first, state declarations of rights in the Revolutionary era. The focus is Virginia, Maryland, and Delaware. This topic piqued my interest after reading his 2002 paper of the same title. And while the paper may sound somewhat esoteric, through its pursuit, we can arrive at a better understanding of the history and durability of individual rights from the American Revolution to the modern day. Judge Friedman's remarks will be followed by a Q&A chaired by Professor Uges, and those of you watching on streaming media will have an opportunity to submit your questions, as Dr. Uges will explain later on. And for the record, tonight's proceedings are being videoed for later publication on the St. Mary's County Historical Society's website. With that, Judge Friedman.
Thank you so much, Mr. Laporte. Good evening. Let me start by saying I'm not a historian. I'm a lawyer and a law professor, and I teach state and federal constitutional law. And I want to explain about our state's constitution, the history of our state's constitution. But I want to take a moment to get us centered on the topic. Each state, each of the 50 states, has its own constitution. Each of those state constitutions is different and reflects differences in the state's history, geography, and other factors. You wouldn't expect Massachusetts's state constitution to look much like Alabama's, or Louisiana's, or Texas's, or Utah's, or Alaska's, or Massachusetts Constitution, by way of using those examples, Massachusetts is the oldest one. It is has been in continuous use since the Revolutionary period, and is the oldest written constitution in the United States. Alabama's constitution, which I mentioned, was adopted in 1901, and it has been amended over 1,000 times since. It's the longest constitution in the world. Louisiana's constitution reflects its civil law and French influence. Texas's constitution reflects its prior status as an independent republic. Utah's constitution reflects a deep commitment to religious freedom, as is appropriate for a state settled by people fleeing from religious prosecution. And Alaska's constitution is among the newest and reflects its self-image as a self-reliant frontier state. Many of the state's constitutions have been revised and replaced, some many, many times. I mentioned Alabama's constitution with its 1,000 amendments. Most state constitutions, like the federal constitution, are built with two parts: a bill or declaration of rights and a frame of government. The U.S. Constitution has it backwards. It has the frame of government first, and for historical reasons that are familiar to students of the federal Constitution, the Bill of Rights comes afterwards as amendments. Most of the state constitutions are organized the other way around: the Declaration of Rights first and the frame of government. Maryland follows that model. We have a Declaration of Rights that consists of 46 relatively short articles protecting the rights of the people of Maryland, and a much longer frame of government. The frame of government has 20 longish articles describing governmental operations. Article 1 states the rules about elective franchise, who gets to vote and how they get to vote. Article 2 sets forth the powers of the governor. Article 3 is the powers of the legislature and restrictions on the powers of the legislature. Judge Kenny and I, our favorite is, of course, Article 4, which describes the judiciary. And it goes on, including provisions about local government, about the referendum power, and now the last article, Article 20, about slot machines. The Maryland Constitution was initially adopted in 1776 and has been revised in 1850 and the winter of 1850 and 1851. It was revised again in 1864, in the middle of the Civil War, and then again in 1867. There was also an unsuccessful attempt to revise it in 1967, 100 years later. But that was rejected, and our Constitution today is still that 1867 Constitution as amended. And it has been amended, not like our friends in Alabama, but over 100 times the Maryland Constitution of 1867 has been amended. Each of these historical periods left its mark on the Maryland Constitution. Our Declaration of Rights was written mostly in 1776, and our Declaration of Rights today is mostly the same rights that were written in 1776 and are clearly descended from the words and the ideas of that declaration. The structure of our Constitution was first adopted in 1850 and 1851, and that structure of the form of government with Article 1, with the elective franchise to the governor, that really dates from 1850 and 1851. The 1864 Constitutional Convention met in the middle of the Civil War. In fact, there was a convention meeting in Annapolis while Early's brought the Confederate Army up the Shenandoah Valley, across the Potomac at Monocacy in Frederick County, and in order to threaten both Washington, D.C. and Baltimore. And so the convention delegates left the convention and went back to defend their farms. And the mark of that, of being written right in the middle of the Civil War, is very much on the face of our Constitution in 1864. And in 1867, only 2 years after the end of the war, the focus of the Constitutional Convention was to put everything back that they had messed up in 1864. And it is our current Constitution is a very reactionary and reactive document. The 1967 Constitution was modern and fancy and spiffy and beautiful, well organized and well written and concise and beautiful, and of course the people overwhelmingly rejected it. I wrote a piece once called, there was a book about the 1967 convention called Magnificent Failure, describing how magnificent the drafting of the Constitution was, but that it failed to be our governing document. I wrote an article based on that called Magnificent Failure Revisited, because by my count, almost every suggestion has subsequently been adopted into our Constitution, but of course not nearly so neat or pretty or organized. So I'm very interested in the Maryland Constitution, and I've made a study of the words and its history and the way the parts work together. And one part that I've studied is how the words used come to be part of our Declaration of Rights and Constitution. And that's what my talk is about today. But before I do, I want to tell you briefly about why I think it matters. There's a belief afoot that our rights as citizens, or at least most of our rights, come from the Federal Bill of Rights. And that's true. I'm not here to argue the opposite point. It's true. The rights protected in our Federal Bill of Rights are important and fundamental, and we deserve the full protection of those rights. But we also have other rights that aren't protected by the Federal Bill of Rights, that are protected by state declarations of rights. Those rights are important and deserve protection too. In various parts of our country's history, there have been periods in which the federal government and other periods in which state governments did a lousy job of protecting the rights of our citizens. But the genius of our federalism system is we have a redundant protection. And so if the federal government is under-protecting our federal rights, we have the state government. When the state government is under-protecting our rights, we have the federal government. And the redundancy of the system is a feature of federalism that helps keep us free. When the government, even when both are working together to protect our rights, there may be disagreement about how best to protect our rights. And even when it looks like the state Declaration of Rights and the federal Bill of Rights are protecting the exact same right, courts can talk to each other about the best ways to protect that right. All those are reasons why we ought to care about state declarations of. Okay, so we'll begin on May 15th of 1776 in Philadelphia, Pennsylvania. The Continental Congress meets and adopts a resolution. This resolution, I wrote it in the font that's supposed to look like the Continental Congress might have written it. It says, resolved that it be recommended to the respective assemblies and conventions of the United Colonies, where no government sufficient to the exigencies of their affairs have been hitherto established, to adopt such government as shall, in the opinion of the representatives of the people, best conduce to the happiness and safety of their constituents in particular and America in general. If you don't have a government, you ought to go write one. And John Adams thought this declaration of May 15th was the real Declaration of Independence, because it was the first time we called for American governments to replace the English government. It's also, Adams called it because he didn't like Jefferson much and wanted to make Jefferson's July 4th Declaration of Independence a little less important. But the point is, the Continental Congress asks each state to write a constitution. This strikes me, and I want to make it clear to you what a tremendously weird thing this was to do in May of 1776. The Battle of Lexington and Concord was fought in April of 1776. Ethan Allen and the Green Mountain Boys captured Fort Ticonderoga in upstate New York in May of 1776. The Battle of Bunker Hill was going to be fought in June of 1776. They were fighting a Revolutionary War right at that time, and in the middle of that war, they wanted us to each sit down and write a constitution. Moreover, they want us to write something that's never been written before. England had no written constitution. They had a king. They had a few documents by which the English kings had agreed to surrender some of their authority, like the Magna Carta, which King John had signed in 1215, like the English Bill of Rights that William and Mary had agreed to in 1689. But those important documents, and I'm not diminishing their importance, were not a constitution. England still doesn't have a real written constitution. The colonies each had a written document that gave them some power, a charter or a compact or some other contract by which the king's power was transferred to a colonial proprietor or governor or company, the Virginia Company, the proprietors. But those documents, nice as they were, weren't real constitutions either. So in the middle of a war, the Continental Congress says, go do something that nobody's ever done before. So the states start writing their own constitutions. It's worth noting that people weren't sure exactly what a written constitution was or what it was supposed to be. Today, we could agree what goes in a constitution. We could agree, for example, that legislatures don't draft constitutions. We have special conventions made up of special delegates whose job it is to write constitutions. We could agree that the product that those delegates write is not voted on by the state legislature and signed by the governor. It's ratified by the people, and that's a different aspect. And in fact, the resulting constitution is superior to ordinary law. And if there's a conflict between a rule of the Constitution and law, the Constitution prevails. That's what the idea of judicial review is about. Is this law acceptable under the Constitution? And if it's not, the law loses. And, by the way, constitutions can only be amended in the same ways, in special ways, that are harder and better and more democratic than law. So we know what those characteristics of a constitution are. But these guys, when they start writing this, they don't know this. They're going to figure it out as we go through. Because there was no tradition of written constitutions leading up to this. Okay. I'm going to leave this slide for a while because I'm going to talk about the chronology through all 4 states in the mid-Atlantic. Virginia goes first. So if the question of the title of my lecture was who goes first, the answer is definitely Virginia. We're going to get to what the order everybody else goes in, which has some interest later. But the answer as a first instance is Virginia. So on January 1st, 1776, the last royal governor of Virginia, who was named the Right Honorable John Murray, the 4th Earl of Dunsmore, he set fire to Norfolk's waterfront and left Virginia, never to return. The state assembly called itself a convention and met to take over governance of the Virginia colony. It was just the state legislature. They would gather, do some government work, write some letters, bring in some taxes, send armies, do whatever governing they did, but they were a legislature. They called themselves a convention because there was no longer any royal governor. The 5th of these conventions gathered on May 6, 1776. Again, this was a legislature. It wasn't called for the special purpose of writing a constitution. We talked about that. Constitutions are written by special conventions. This wasn't a special convention. But they gathered and they decided that they were going to write a constitution. On May 15th, 1776, remember, you probably remember that date. There it is, May 15th, 1776. That same day that this resolution was getting written in Philadelphia, that same day down in Jamestown, I guess, the Virginia convention met, and they decided to call on its delegates to the Continental Congress to declare independence. So Adams calls this the Declaration of Independence. Virginia says, you guys ought to be declaring independence. Well, maybe they did or maybe they didn't. So they send their guy from Jamestown up to Philadelphia. This is a point of personal privilege. My father-in-law, his name was Thomas Nelson Ruth. The guy that they sent was his 8th grandfather, Thomas Nelson of Jamestown. He rides out of Jamestown. He later becomes governor of Virginia. He rides out of Jamestown, goes up to Philadelphia to tell them, we want you to declare independence. So Jonah Friedman, who we talked about before, his 9th or 10th great-grandfather. All right. So So Virginia started to set out to draft a state constitution. They appointed a 27-member committee. Have you ever been on a committee? How many is 27? That's too many. Two critical things happen, though, almost right away. There's a vacancy, and so they call in a substitute, and they bring in a planter from Northern Virginia to join the committee. And the new member was a grouch. He's grumpy. He thinks this 27-member committee is too big. And so the planter, whose name was George Mason, got together with his friend Thomas Ludwell Lee, and the two of them sat down and wrote their own Virginia Declaration of Rights. And Mason's draft was so good that they read it in front of the convention, and that was the draft. Mason's May 27th draft is the critical document. It gets circulated throughout the world. And it's really the work of just those two guys, Thomas Ludwell Lee and George Mason. And the May 27th draft is hand-carried throughout the colonies. It's reproduced in every newspaper in all of the colonies. It goes in pamphlets and in broadsides. They say it's a model for the Declaration of Independence. A copy goes to France. And the people who are drafting a couple of years later, the Declaration of Rights of Man, I wouldn't embarrass myself with my French accent, the Declaration of Rights of Man, the Mason draft is influential. So will you excuse, this paragraph is too long, but it amuses me no end. The president of the College of William and Mary describes the May 27th draft. The Virginia Declaration of Rights is indeed a remarkable production. As an intellectual effort, it possesses exalted merit. It is the quintessence of all the great principles and doctrines of freedom which have been wrought out by the people of England from the earliest times. To have written such a paper required the taste of a scholar, the wisdom of a statesman, and the purity of a patriot. The critical eye can detect in its 16 sections the history of England in miniature, that it should have been thrown off by George Mason, a planter, hastily summoned from his plow to fill a vacancy in the public councils, who was not a lawyer and who performed his work so thoroughly that it has neither received nor required any alteration or amendment for more than 3/4 of a century, fills the mind with admiration and grandeur. So Professor Grigsby liked it. He thought it was pretty good. So the May 27th draft, they make a few edits, and we're back here, and on June 12th, it's adopted. So if you were looking for what gets transmitted, it is not the June 12th draft of the Declaration of Rights. It's the May 27th that goes to other colonies. So Pennsylvania had its assembly, its state assembly in early 1776 was very conservative. The assembly had instructed its delegates to the Continental Congress to oppose independence. Not like the Virginia guys who were sending Thomas Nelson up to tell them to vote for independence. Pennsylvania doesn't want independence. And they're sending their guys cross town. Remember, the Pennsylvania Assembly is meeting in Philadelphia. The Continental Congress is meeting in Philadelphia. It's all happening in Philadelphia. Historians think that one of the reasons for the May 15th resolution by the Continental Congress was trying to get Pennsylvania moving. But it wasn't going to work because there were elections in May, and the conservative assembly was being replaced by a more conservative assembly. It was scheduled to begin its work on May 20th. So without any real legal authority whatsoever, they called for a provincial conference. It approved the May 15th resolution, and on June 23rd called for a constitutional convention to convene on July 15th. Why? Because they needed to. The point, they called for a constitutional convention. It wasn't because they wanted a superior body in the way we talked about who drafts constitutions. It was because they didn't want those guys who weren't going to vote for independence. It was a purely political ploy. Ironically, that constitutional convention was the most radical of any of the 13 colonies. And they drafted the most radically democratic constitution. In all of the other constitutions, there were, for example, property qualifications. You had to own enough property to be able to vote or to hold office. Pennsylvania, because they didn't want the rabble to have the right to run government. Pennsylvania eliminated all of those property requirements. Pennsylvania 1776 Constitution had a unicameral legislature. No Senate in which to operate as a saucer to cool off the tea for the Pennsylvanians. They were content with their hot tea. And that was considered much more radical. And that first Pennsylvania Constitution had a very weak collective executive. Essentially, a council was the executive branch. There was a president, but he was really a figurehead with a one-year term. They did not want any more kings in Pennsylvania. The Pennsylvanians did not use the May 27th Mason draft as a model for their Declaration of Rights. They pretty much drafted their own Declaration of Rights from scratch. I'm going to come back to that because that is a little bit of a controversial point. Professor Max Ferrand thinks that they were working from the Virginia draft, but the text is very different. It's worth noting that although the people didn't get to ratify the Pennsylvania Constitution, ratification being a hallmark of a constitution, the Pennsylvanians sent it out for a period of public comment. For 3 weeks, everybody went home and said, is it okay? Do you like it? It wasn't really ratification, but you see, the Virginians hadn't done that, and the Pennsylvanians, the idea of constitutionalism is evolving. The third state is Maryland. Maryland's colonial governor, Sir Robert Eden, left voluntarily in 1774, and Maryland was governing itself for 2 years after, by convention. After the 8th of these conventions, Maryland called elections to a 9th convention. And when they did, they said it was for the, quote, express purpose of drafting a state constitution as directed by the May 15th resolution. So as we're seeing the development of constitutionalism, the first two are doing it, Virginia did it by its legislature. Pennsylvania does it by a special group, but not because it had any legal authority, but because they did it for political reasons. By Maryland, they've figured out that they want to have a special convention only for this purpose. They met in Annapolis on August 14th of 1776, and by August 17th, they selected a drafting committee to write the fundamental documents. They also, whether they knew about the 27-member Virginia committee, it's not clear to me. But they settled on a 7-member committee. Charles Carroll, the barrister, Charles Carroll of Carrollton, future Supreme Court Justice Samuel Chase, Robert Goldsborough, William Paca, George Plater III from here in St. Mary's County, Sotterley Plantation, and Matthew Tillman from the Eastern Shore, where his family had an island named after them. We know that they had Mason's May 27th draft and Pennsylvania's August 16th draft, but they liked the Virginia draft and didn't much care for that Pennsylvania draft, especially since they knew that those Pennsylvania guys had been so radical. The Maryland framers finished their first draft of the Declaration of Rights on August 27th. We then lost that draft to history for a long time. They finished their first draft of a frame of government on September 10th. They revise both, and then they publicly circulate both, just like the Pennsylvanians did, for a public comment period. Not as good as ratification, but an improvement. Both documents were finally adopted on November 8th. The first drafts are really good. There were very few changes made in the revision. The Maryland frame of government has another first step on the road to modern constitutionalism. It had the first provision for its own amendment. According to the Maryland Constitution of 1776, the Constitution can be amended by the legislature, but it had to be passed by 2 consecutive sessions of the state legislature with an intervening election. So if you really hated that amendment that your state legislator had voted for, you vote him out of office and send somebody down next time who won't support that amendment. And that was a way of starting to create constitutions as superior law. I'm going to come back to the text of the Maryland Declaration of Rights. In Delaware, they start on July 27th. The Speaker of the Assembly, Caesar Rodney, called for a special session to draft a state constitution. They met on August 27th. They worked quickly. They had a Declaration of Rights by September 11th, a form of government by September 17th, no public comment period, and they wrapped the whole thing up by September 20th. So Delaware started earlier and started later and finished earlier than Maryland. As I mentioned earlier, the Maryland August 27th draft was mostly lost to history. Given the timelines here, Professor Max Ferrand, who was a famous historian, wrote an 1897 article published in the American Historical Review that said that Delaware came first and that Maryland copied Delaware. So Professor Ferrand thought it happened in this way, that Virginia drafted first, that Pennsylvania copied from Virginia, that Delaware copied from Pennsylvania, and that Maryland copied from Delaware. This I could not stand. And it turns out that this is wrong. We found evidence later. First, we found the August 27th draft, and it is clearly prior to Delaware. Historians also found a letter from George Reed to Caesar Rodney that says, in effect, we copied Maryland's draft. We also know that Delaware didn't care for Pennsylvania's draft, neither did Maryland, because it was too radical, and both Delaware and Maryland were more conservative. So this is really the drafting order, what I call the Friedman revised drafting order. Maryland worked from the Virginia draft. Pennsylvania had the Virginia draft, but I've drawn a dotted line because they didn't much pay attention to it. Delaware had both the Maryland and Pennsylvania as well as the Virginia, but they were working off the improved drafts. Delaware really very much copied the Maryland draft. And that's the answer to that. Now, what I would like to turn to is how that matters and what we could see. And so the next slide is from the May 27th Virginia draft of the rights of those people that are accused of crimes, right? So we are, let me make sure I've said that correctly. We are in the Virginia May 27th draft. This is the one that goes around the world. This is Article 10. There were other articles dealing with other things, but this is the article about the protection of folks who are accused of crimes. It consists of several things. What I'm going to do is just turn them red. So, the introduction, that in all capital or criminal prosecutions, a man hath a right to demand the cause and nature of his accusation. That's what we're going to call the presentment right. To be confronted with the accusers or witnesses, that's the confrontation right. To call for evidence in his favor, the right to evidence. And to a speedy trial by an impartial jury of his vicinage. We have a debate about whether that's in New Jersey, that's definitely pronounced vicinage. I'm told there's an alternative pronunciation of vicinage, but I am not clear on that. But we'll come back and talk about what it means in just a minute. Without whose unanimous consent he cannot be found guilty, nor can he be compelled to give evidence against himself, the right against self-incrimination, and that no man be deprived of his liberty except by the law of the land or by the judgment of his peers, what I will call the right to due process. Now, Mason left out some good ones. He left out the right to the writ of habeas corpus. We like that. He left out a right to counsel. He left out a right to grand jury proceedings. He left out prohibitions on double jeopardy. He left out prohibitions on bills of attainder and against ex post facto laws, all of which we consider as part of the constellation of of the rights of criminally accused. But he did a pretty good job at hitting 7 of the high points. So what did the Maryland drafters do when they got this master work by George Mason? Well, so the introduction, Mason's draft had it that in all capital, death penalty, or criminal prosecutions a man hath. What did the Marylanders do? Well, what the Maryland drafters always do is add commas. They're wild for commas for reasons I can't really always understand. That comma, I don't think has any real value. I don't know why they added the word every. There's no historical record that would suggest it. I have a thought, but I don't know if it was intended to include enslaved persons or to create a difference with our friends to the south. But they added the word every, and I think that's something we ought to be cognizant of. The second phrase, the presentment right. Mason writes it, they have a right to demand the cause and nature of his accusation. Well, you get to ask for it, big deal. Here, Maryland looks at that and says, well, that's not quite right. You have a right to be informed. You don't just get to ask for it, you get to be informed of the accusations. That's an improvement on the right? And that gets it right. What did Maryland do next? Oh, Virginia, we talked about it, didn't have a right to counsel. Maryland, in drafting what is currently Article 21 of our Declaration of Rights, just adds it in to be allowed counsel. That's a good one. Right to confrontation. So what do? The Maryland drafters didn't figure out anything worthwhile, useful to do, so they did what they always did, add an extra comma that doesn't really move anything. On the right to call for evidence, let me talk about this. At early common law, the defendant didn't have a right to call for evidence. It was expected that everybody lived in the same area and knew the facts. They knew everybody, and they knew what had happened. So you didn't need to put on evidence. Later, in the common law, in England, defendants were allowed to call witnesses, but the witnesses weren't allowed to be sworn. But by the end of the 17th century, defense witnesses were not only able to be called, but to be called and sworn. So by the time this was written, the right of all English people wasn't just to call for the evidence in his favor, but it was to examine the evidence on oath. You get to swear the witnesses. So what the Maryland drafters did is they took Mason's language, which is great, but they made it better. And they knew how the common law had evolved and how to improve it. So Virginia has speedy trial, impartial jury, skip the vicarage, we'll come back to it, without whose unanimous consent cannot be found guilty. We do the same thing. Speedy trial, impartial jury, unanimous consent. But they also had that vicarage thing. What did we do? Well, let's talk about what vicarage meant. Vicarage meant the place from which jurors would be summoned. It is not the same thing as venue, which is where the trial occurs. And at old common law, it had been important because we didn't have defense witnesses who were sworn. We needed people who were from the place who knew already what had happened. So it was an important protection that you had people from the vicarage. By 1776, that wasn't how it worked anymore. We didn't need jurors from the place. We needed trials to be held at the same venue. So Maryland takes it out of this whole provision and creates a new article, a wholly new article, that talks about venue. And it says that the trial of facts where they arise is one of the greatest securities of the lives, liberties, and estates of the people. So this is no longer, we just cut it right out of that criminal provision and made it its own independent. What is the significance of that? Well, one is we're making a bigger deal of it by making it its own independent thing. This was, it's worth noting, one of the things about which Jefferson had complained in the Declaration of Independence. What the king and the British did for serious crimes, and particularly political crimes, is they would transport you back to England and you would be tried there, where it would be a guaranteed win for the crown. And one of the complaints was, no, you can't have trials in England for things that happen here. You need trials here for things that happen here. And so this echoes that exact point. We need trials here. I also think it is arguable that getting it out of Article 10, out of the criminal rights provision, it no longer is preceded by the introductory language. Remember the introductory language. In all capital and criminal prosecutions, you get this right. But this is not so limited. It seems to me that Article 18, which is now Article maybe 22, now I got to check myself. No, it can't be 22. 20. It's now Article 20, of course. Article 20 is applicable not just in a criminal context, but also applicable in a civil context. I don't know that that's true, but it's at least arguable when you look at the words and how they were taken out. They also took the right Remember, in Mason's draft, the right against self-incrimination is part of that constellation of criminal rights. The Maryland drafters take it out and move it to Article 20, now Article 22, that no man in the courts of common law ought to be compelled to give evidence against himself. So they're using the same language that Mason had used, but they've moved it out either to maybe to emphasize it, maybe to also make it applicable in a civil context. Not sure. It doesn't matter, though, because by 1864, they say they change the language and make it specifically only in a criminal context. The last right in Mason's May 27th draft of Article 10 is the right to due process. And he had said, remember, that in every criminal prosecution, capital and criminal, a man hath a right, and that no man be deprived of his liberty except by the law of the land or the judgment of his peers. So Mason's draft says, in criminal context, when your liberty rights are at stake, you get procedural regularity. That's what that means. And the Maryland drafters read that and they say, oh, that's pretty good, George. Good work. But let's see how we can make it better. They said, oh, first thing we're going to do is make it an independent provision. We're going to make it its own. And then they look at it and they say, I wonder where George got that language. Oh, that's from the Magna Carta. I recognize that. And they take it and they put back in language from the Magna Carta. Mason is using language from the Magna Carta, law of the land, judgment of his peers, straight from Magna Carta. Those are quotes. But in the Magna Carta, it protected not just liberty, but also life and property. So they went back, looked at the source document, and fixed Mason's draft to make sure that it covered everything. So really interesting, it's only a liberty interest. Why is it all? It could have been, we know it's in capital and criminal prosecutions. He should have had life in there, right? That's an interest that was threatened by the criminal prosecution that should have been protected. The Maryland framers put in life, liberty, and property, which also suggests, again, probably a civil context. It's also worth noting that elsewhere the Maryland framers added a few other criminal protections that Mason forgot. We added in a prohibition against bills of attainder. We added a prohibition against ex post facto laws, which is now Article 17. Still don't know what it means, but we protect it. But our framers didn't think to add that prohibition on double jeopardy. And if you look at the Maryland Constitution today, there is no prohibition on double jeopardy. And if you have a protection against double jeopardy, it is only protected by the federal Constitution or by the Maryland common law, judge-made law. So we see the way that the Maryland framers took that Virginia language and improved it. So I return to my earlier question, does it matter? In some ways it shouldn't. These were intended to be universal rights, not precise rubrics. The Pennsylvania framers thought that they had the same rights as Virginians, and they all had the same rights as Englishmen. In other ways, however, small differences matter. Modern judges and lawyers fight every day about small textual differences. We decide cases every day based on the meanings of these rights. It's critical for me, to understand it, and the point of my lecture is that they weren't mindless monkeys copying it. In Professor Ferrand's retelling, everybody was copying Mason's May 27th draft. But I think what I've tried to do is demonstrate to you that they were working hard to get it right. They made every change they could to improve it and to protect your rights as Marylanders. And that is what was happening. And that's who's first, and that's what was happening in the summer of 1776.
Thank you.